For the Kenyan delegation at the 12th ICC member states meeting that ended today at the Hague, Netherlands, it was in its assessment a successful outing.
All that we came to achieve at this assembly of state parties, we have achieved.
The main amendment that was passed by the plenary Wednesday night on Rule 134 of the ICC Rules of Evidence and Procedure, granting Kenyatta and Ruto an opportunity to request the trial chambers handling their cases to allow them waive their right to be present in court and instead be represented by their lawyers. The amendment providing an opportunity for the president and his deputy to seek excusal from their trial proceedings on the basis of the offices they hold and the functions they are required to perform.
This amendment has secured a fine distinction between the immunity of a head of state, which will be dealt with by the treaty at an appropriate time, as I have stated, and attendance before court, which is a procedural question.
And as the Kenyan team at the Hague meeting led by Foreign Affairs Cabinet Secretary Amina Mohamed and Attorney General Professor Githu Muigai reviews its performance at the just concluded Assembly of State Parties meeting, international law experts say Kenyatta and Ruto are not yet out of the woods.
It doesn't change anything legally because it does not automatically grant a right to be away. You still need to apply to the judges, and the judges will have to consider that application in terms of the statute and the new rule that has been developed. Although in my view it doesn't change much legally, politically it does. And I think it's a huge political victory for Kenya in the sense that it changes the political environment in which the judges will be considering that application.
On 5th February next year, Kenyatta has the date with the trial chamber handling his case, presided by Judge Kuniko Ozaki. The ultimate question remains, will he honor the summons to appear, or will he comply with the directive of the African Union to skip the ICC trial sessions? And is it possible for the president to take a plea on the 5 counts of crimes against humanity charges that he faces at the ICC through his legal team, or even through a video link from Nairobi? Or will he be required to physically appear before the trial chamber at The Hague to plead guilty or not?
No, you cannot. I don't think that you can take a plea through your lawyer. If the reasoning of the chamber applies, which is that presence of the accused means physical presence, we will exercise our discretion to allow you to be away, but there are at least a number of days you must attend court. And one of those would be when the trial is opening. At least that you have to be there. They will then decide. What other important days you'll be required to be there. Of course, if you introduce video link, it in fact allows the court to exercise greater flexibility.
The ICC Appeals Chamber, in its interpretation of Article 63 of the Rome Statute, ruled that accused persons must be physically present in court during their trial and only exempted by the trial chamber on a case-by-case basis. The Kenyan team at the ICC State Parties meeting insists that the amendment to Rule 134 of the court's procedures has nullified the Appeals Chamber's ruling.
And the ASP, I think, has been careful not to pass an amendment that is in violation of Article 63. They cannot do that. So until such time that Article 63 is amended to provide for an automatic right to be absent for certain individuals, like a president, we are stuck with the old law. Although it will be interpreted going on forward, in my view, and should, with greater flexibility.
The ICC member states also adopted an amendment to the rules and procedures, allowing suspects to waive their right to be physically present in court and use video links from Nairobi to follow the proceedings at the Hague courtroom, but subject to the trial chamber's approval. Francis Gachuri, Citizen Live at 9.